she's asking about is saying that the ordinance has to be shown to be unreasonable, et cetera, with no reasonable relationship to the promotion of public health, safety, or welfare. That's a key phrase, relationship to the promotion of public health, safety, and welfare. That's a key phrase because an Iowa statute, Iowa law, uses that phrase as one of the responsibilities of the Board of Supervisors in executing their jobs and passing their ordinances. In fact, we'll see that in the language here in just a moment. Other questions? Not sure what happened to my slide deck there. I got out of order here. So, don't look at the man behind the curtain. The first one there, this is what we were just talking about. Iowa Code 333.301 grants county supervisors the authority, this is a quote from the state code, exercise any power and perform any function it deems appropriate to protect and preserve the rights, privileges, and property of the county or of its residents, and to preserve and improve the peace, safety, health, welfare, comfort, and convenience of its residents. That's a job, an obligation of the county supervisors according to Iowa state law. This is why the Supreme Court has said if the Board of Supervisors or city council, whomever it may be, when these municipal governing bodies pass their legislation and pass these ordinances, those ordinances are assumed to be valid. And the court is going to rely on the plain language of those ordinances. And challengers to those ordinances have to prove that they're unreasonable, capricious, et cetera, et cetera. It's rooted in that law. Iowa Code 335 says that with regard to zoning regulations shall be made in accordance with a comprehensive plan. So each county should have a comprehensive plan. That comprehensive plan should be designed to do a variety of things. One of the things that the state code says that that county plan is supposed to do is to protect the health and general welfare. Now there's a lot of other things. It's supposed to help develop industry. It's supposed to preserve agriculture. There's a whole litany of things. But protecting the health and general welfare is one of the things that is specified there that that county plan is supposed to do. Down one level from that county plan is the county zoning ordinance. The county zoning ordinance is supposed to implement rules that will comply with and achieve the goals that are set out in those county plans. And the county zoning commission is the one that, according to state law, is supposed to provide the recommendations of those ordinances, the zoning ordinances, land use ordinances. Those originate at the zoning commission, and then they provide those recommendations to the Board of Supervisors. And before any of that happens, of course, there's hearings. In fact, the detailed activities for the ordinance dictated by law for the countywide plan, you have a plan that's drafted. It may be drafted by the zoning commission, it may be drafted by the Board of Supervisors, it may be drafted by special committee. However it's drafted, that plan is drafted. The zoning commission reviews that plan and makes their recommendations. They have a public hearing on their recommendations, and then they make changes as they may determine. Then they forward their ultimate recommendation to the supervisors. The supervisors do the same thing. They have a public hearing. They may make changes as a result of that public hearing, and then ultimately it's the supervisor's call. They vote on it and decide what is the content of these plans. With regard to zoning, the same thing applies. The zoning ordinances, those plans are originated by the zoning commission. And they go through that same process. Public hearing, changes, report and recommendation, and so on. And I want to emphasize this because some people have the erroneous belief that the zoning ordinance is something that is controlled by the county zoning administrator. And that's frankly not accurate. If you read the state code, it originates with the zoning commission. The administrator administers the ordinance once it's been passed. In fact, with regard to the zoning commission, the zoning administrator is a member of the zoning commission board as a secretary, not a voting member. The voting members are those that are appointed by the county supervisors. I'll talk briefly about the philosophy that drove the approach, my approach anyway, at Worth County. Before I do that, I want to ask a question now because we're going to get into some nitty-gritties here. How many people here are landowners that have signed or are considering a wind easement? Just a show of hands. Just a few. And how many here are landowners that are just here for information? You haven't been approached yet, you're just wanting to learn? A few. And how many here have businesses or are responsible for schools or businesses in the area? None? One? Okay, good. Two? How many here are members of the zoning commission? Couple. Good. And how many here are members of the board of supervisors? Any? Got one. Good. Are there any here that are employees or representatives of the any of the energy companies? A couple of them. Three of them. Good. So the reason I did that survey is I want to point out that there are a whole slew of stakeholders. When it comes to this question, it becomes a very, very pointed, sometimes emotional impact to individuals on this question of wind turbines, commercial wind turbines. Because the reality is there's a lot of benefits and impacts that get spread around to a lot of different people. There's a lot of stakeholders involved in this stuff. And we have to make certain that we're talking about those folks. Now, I start with this preamble of the U.S. Constitution. And I have highlighted in bold, just as the United States Constitution does, the phrase, "we the people." Because the Constitution then goes on to present why it's necessary, and essentially, as it was established in the Declaration of Independence, it establishes that the people are the entities vested with the inalienable rights, the citizens. And these rights are vested solely to us. Then the people decided that in order to have and guide a civil society, we need rules. We need a government to implement and enforce those rules. Protect those liberties, those rights that we have. That forms the fundamental basis for all of the rules, is the protection of rights and liberties. And as I said, we saw from our show of hands, there's a wide variety of stakeholders. Counties can't survive if they're not open to business. If all the counties were just individual homes scattered throughout the county, people living on acreages, there's no money to maintain the roads, there's no money for schools, there's no incentive for stores and businesses in the county. So it takes a collection of all of these things. But the reality is, No one should be able to demand their way to the exclusion of all others. We have to compromise, and we have to make certain that we don't forget that the rights begin with the people. So we can't allow these ginormous companies with gobs of money and lawyers that have far more experience in courts than our lawyers do to just run roughshod and bulldoze over us. Laws and the rules are established for the protection of the rights of the people and to ensure a civil society. So those competing rights have to be balanced. So if you're looking to make changes to your ordinance, by all means, absolutely, you need to reach out to all of these different stakeholders and ask for input. We spent hours upon hours interviewing lots and lots of people from a variety of stakeholders, including, as I said, the energy companies. Again, things change, so the rules have to change. We're going to talk just a little bit about the ordinance in Worth County. It's been characterized by some people as saying that the ordinance is extreme and that it's not consistent with other related ordinances in Iowa. It's not like the average wind ordinance in Iowa. And I would say if your measure of extreme is, does the Worth County ordinance look like most of the other ordinances in Iowa? No, it doesn't. And so if that's the measure of extreme, then maybe it is. It's not a half a page long. It's upwards of 30 pages long. If that's your measure of extreme, then it is. But I would submit, and I know for a fact because we did the research, we looked at ordinances across every region of Iowa, and the vast majority of them were 10 to 15 years old. Additionally, many of them, it was like a collection. Collection A, this group of ordinances, they all said the same thing. It's like they copied off each other. It came from a pattern book. This other group of ordinances, written in a different time period, they used a different copy book. They all very much said the same. Worth County, turbine fires. If the fire distributes burning stuff all over the property, oh well. You've got to protect, in my opinion, not just the house, but the property, because I believe that's where the property rights begin.
Was there any pushback on that?
Well, as I said, the zoning commission was unanimous that that's where property rights begin. The supervisors changed the ordinance with some of those setbacks to apply to buildings.
Nobody pushed back on, I mean, them doing.
Well, some people did, but you know, it's the supervisor's call. It's their ordinance. So her question is, did people push back on it? And the answer is yes. Some people pushed back and said, no, keep it at the property. But it is the supervisor's ordinance. And their argument, and the energy company's argument was, well, if you apply all of these setbacks to the property line, then that means we got to be that much farther back, and that takes away that much more land for us to be able to develop. And some landowners who were hoping to get a turbine and the money that goes along with getting a turbine says, well, now wait a minute, the energy company says they're not going to put a turbine on my land if these are the limits because they don't have enough space, and I want a turbine on my land. I want the income from that turbine. And so as I said, it goes back to, there's a lot of stakeholders involved in this. And those conversations have to be held. Ultimately, it's the supervisors that are going to decide, but it's the input that they get that are going to help them make their decision. So those are just some of the examples of things that are in our ordinance. I'm not going to go through everything that's there. As I said, it's available on our county website. You're free to look at it, download it. If you've got questions on it, I'm more than happy to answer them. All right, last couple of slides, we're going to talk about wind easements. Again, I'm not a lawyer. Neither is the land agent that's coming to you, knocking on your door, saying, I'm going to promise you all these things, and here's the agreement, sign here. They're not an attorney either. In fact, they can't even officially, legally speak for the energy companies. What they say, frankly, doesn't matter. What matters is what's in the agreement. Their interest is in getting signatures because that's how they get paid. The agreements expressly state, and again, these are agreements that I've read. I don't know what agreements they're handing you today, but the agreements expressly state that the agreement contains the controlling terms, and any oral agreement or other written agreements not expressly part of this agreement is superseded, null, and void. So it's only what's on that paper that's counted. So if they told you one thing and you can't see it in plain English, demand it be put in plain English. Otherwise, it ain't gonna be there. The agreements often state that the grant that you're granting them is for the sole authority of any and all activities related to collecting, converting, and transmitting energy into electrical energy on the property. So in other words, if it deals with wind energy and the transmission of wind energy, it's their call. They can do anything they want, wherever and whenever they want, according to the terms of those easements. You also forfeit any rights or compensation that are not explicitly stated in the agreement for any effects of the agreement. Noise, shadow, electrical interference, property damage, or, quote, other effects, and that's a quote from the agreements, that is attributable to the work on the turbines. You also waive enforcement of any local, state, or federal regulation related to wind development on your property, according to some of these agreements. You need to be careful of these terms. As I said, you need to get a good lawyer to go over this stuff for you. These agreements also typically run with the land regardless of ownership, sometimes for as long as 50 years. I can't tell you the number of people that we heard from that were just beside themselves trying to figure out ways that they could get around things in the agreement because their parents or their grandparents had sold the wind easements to the energy company, and the energy company says, we're going to come in and do X, Y, Z. And they're saying, but I built my house over here. I don't want that there. That's too bad. Those rights were given up as a part of the agreement, and those rights run with the land. It states that each party has had the benefit of review by legal representation. It states that in the agreement because if you go to court later and say, well, I didn't really understand what this term meant, the court's going to say, well, that's too bad. It says here you had the opportunity for a lawyer to look at that stuff on your behalf. If you failed to do so, that's on you. That's why that statement is there. So get a lawyer that's good at that stuff because you're screwed after the fact. Any legal issues regarding the land or its use as a result of wind power facilities will be controlled by them according to the agreement. You may not plant trees or erect anything that they deem may interfere with their activities or the wind. So now you got to ask their permission. If they've got wind turbines on your property, you can't do anything if they say that might impact the wind that's going through those turbines. It effectively cuts out any tenant farmers for saying anything. Are there any tenant farmers in here? Any landowners that lease land to tenants? A few of them. Your tenants effectively don't have a say in this stuff now, according to many of these agreements. Now, all of these agreements and all of these terms that I'm going through, those are subject to your negotiation. Do it through legal counsel. And if you're concerned about your tenants, make sure you involve them and have that injected in the agreement as well. Otherwise, they're cut out. They have no say on anything. The terms often say that except for a few exceptions that are favorable to them, you can't initiate any action to terminate or cancel the agreement after the fact. Just says right there, once you sign it, you're done. You can't challenge it. And they don't have to inform you of anything after you've signed it, even if they sell the rights to another developer. That's their right. They can sell it, do whatever they want. They don't have to tell you squat. This next one is kind of a big one. It's related to a legal doctrine called rules of construction. Rules of construction essentially say that if there's an arbitrary clause, if I write this agreement, right? I write this agreement, and I'm going to give this agreement to Candace. And we sign it. We both agree to it. Later on, we find there's a clause in here that's kind of ambiguous. And depending on how it's interpreted, it could either go in my favor or it could go in her favor. Alternatively, disfavor me or disfavor her, right? That legal doctrine of rules of construction says if I wrote it and there's an ambiguous clause in here that could be interpreted one way or the other, the court has to interpret it to my disfavor. In other words, it's to her favor. The theory being, I wrote it, I should have known better. And if I wrote it ambiguous, I was probably doing it to be tricky. That's why that doctrine exists. Some of these agreements have a clause that explicitly state that this doctrine of rules of construction is expressly waived and shall not be employed with regard to this agreement. Isn't that something?
Wow.
A doctrine that's there to protect people with these agreements, and they write that doctrine out as a part of the agreement. You also waive the right to a trial by jury and any rights to be part of a class action that's based on any litigation in connection with the agreements. And finally, you agree to indemnify and hold them harmless as a result of a very wide range of things, too many for me to put on the slide, that is effectively anything they can think of, you're agreeing to indemnify and hold them harmless from all of these things. Again, those are clauses that were in easement agreements that I read a couple of years ago. I don't know if they're in easement agreements that are being looked at today or not. The lesson here, what I'm trying to emphasize by going through these things, is there's a lot of stuff in those agreements that you may or may not agree to. You really need to get an attorney to look at those agreements for you before you sign them. With that, I am done with my slides. What questions do you have? Yes?
So when you sign one of these contracts, it doesn't apply just, does it or does it not apply just to the spot where that windmill sits on my land, or is it more than that?
Typically, and again, devil is in the details, right? You have to look at the individual agreement. But typically, these agreements are for parcels of land. So it may describe 40, 60, 180, 240 acres. Whatever land is encompassed under that agreement, you're giving them carte blanche to do what they want on that 240 acres, wherever they want.
I would add to that the one that the draft easement agreement that was never signed, that we were given back in 2018 by Invenergy, said that, yes, it was over the entire parcel, but at the end of the development period, they may decide that they don't need all of your parcel, okay? So that you might not get a turbine payment, but you were paid on so much money for all the land that you signed up. And they did this up in Minnesota. They actually cut their leases by 25%. However, in the draft agreement, it said that if they so chose in the future to access that a land that you had originally signed up, they could. And I have that here. So it's very tricky.
And they don't necessarily have to pay you?
Yeah, it says at a future date, if they decide they need access to that, they can.
As I said, devil's in the details.
So does Worth County keep track of how many easements are signed? So how many acres are signed over to these other companies?
No, the energy company knows how many easements that they've purchased and, you know, how many acres those easements encompass. And the information is publicly available because the easements are filed with the recorder's office. So if somebody wanted to do the research, you could do the research and find out.
You can also go on Iowa Land Records, and if anybody wants to come up here and take a picture of this, this is how you go on there. It's free, and you can see who has signed up for easements. A note on that, though, is that they don't sign the easement and then just file it. They'll hold them and then file a number at a time. And if you go and look at that and you try and look up too many, it'll block you out for a while. So you can only look up so many. But that's up here for if you want to take a picture of it.
The questions? Oh, yes.
All this stuff, what's the name of the company?
Invenergy?
Well, in Worth County, it's Invenergy, yeah.
Okay, is this what they did 20 years ago? Have they modified since then? And are they just fly by night?
Oh, no. So the question is this a company that's been doing stuff for 20 years, and are they a fly-by-night company or something? No, they're actually, if not the largest, one of the largest. Merlin, do you know if they're the largest privately held energy developer? Yeah, the largest privately held energy developer in the world.
And then NextEra would be the largest renewable energy generating company, I believe, in the world.
Yeah,
They own Florida Light and Power.
yeah, they are, and because they're privately held, there's a lot of information that's not publicly available, but it's estimated there are hundreds of billions of dollars in revenue. But what they'll do is they'll create a company, like they did in Worth County. They created, well, in Freeborn County, they created Freeborn Wind, LLC, small little company expressly for the purpose of putting in wind development in Freeborn County, Minnesota, and then actually put it in Worth County. They did with Worthwhile Wind on the west part of Worth County. This is the project that is pending court decision now. That was Worthwhile Wind Limited Liability Company, expressly for the purpose of putting in one project in the west and central part of the county.
Oftentimes, though, do you agree they will sell that off?
Oh, that their business pattern is they don't always sell it. Sometimes they'll actually dig in and create the wind turbines and maybe even operate them. But generally what happens is they'll come in, they'll do what they call develop the project, which is buy the easements, do the plans, determine what turbines are appropriate, get the permits, and then they'll sell that to a company that'll actually put the stuff in. And then sometimes that company will then run it, and other times that company, once they construct it, they'll turn around and sell it to somebody else to actually operate it.
Did landowners have the opportunity to give them an easement for 1 acre and a 75-foot easement?
So the question is, do the landowners have an opportunity to say, I'm going to give you a wind easement on this 1 acre, but not the rest of my holdings? That's a conversation you have to have with them. I'm guessing the land agent is going to say no, because we don't know where we're going to put a turbine. We're buying up all of this land in hopes that we're going to be able to have enough land to make a project viable. And then we'll decide where we're going to put the turbines. So my guess is they're probably not going to be inclined to say just this little small part. Maybe they will, maybe they won't. But again, that's a conversation that would have to be between you and them. Yes?
Is the time frame, like the 50 years out, is that specified language in each of the easements? Because with the CO2 lines, they're all perpetual, forever easements.
Yeah, so the question was, in the easement agreements, is the timeline of 50 years or 30 years, is that spelled out in the agreements? It is, and it is, it's spelled out, but not necessarily clear. Because it will say you're granting this easement for this project for N number of years life expectancy of the turbines in this project. But they have the rights, as a part of the agreement, to extend that. On their call, they can extend it. You can't stop it. And so if you look at those extensions, they're typically on into 30 and 50 years.
To follow up on that, they have language in there that says they can abandon in place